of Merifon PTY Limited and Greater Letaba Municipality and another for hearing. Council are now invited to place themselves on record. Please note that this hearing is being recorded.
Thank you, Ms. Jones. Where's Mr. Da Silva? Mr. Da Silva?
I don't see just Mr. De Silva, Justice Mhlanga.
He's
here.
Oh, there, I
The
see
bottom,
him.
bottom left.
I see him, yeah.
Yeah.
Mr. Da Silva, can you hear us?
Muted.
Yes.
Justice Mhlanga.
Yes, Mr. Lamy.
I apologize. Mr. Carlos Da Silva was just a moment away from his computer, but he's back now.
Oh, thank you very much. Thank you. Thanks, Mr. Lamy. Yes, Mr. Da Silva.
Mate, please, I appear on behalf of the appellant, begin with my learned junior, Advocate Albert Lamy.
Thank you, Mr. Da Silva.
May it please the court, Justice Mhlanga, I appear on behalf of the appellant A.B. Rousseau SC for the record, together with Mr. J.A.L. Pretorius.
Thank you, Mr. Rousseau. Yes, Mr. Da Silva. And may colleagues remember that we are at liberty to start putting questions to Mr. Da Silva right away. Yes, Mr. Da Silva, you may start.
Unmute. He's muted.
Mr. Da Silva, you are muted. You are on mute. And please restart.
May it please you.
Yes. Isn't there another device that's on or right where you are, Mr. Da Silva? It must be switched off, please.
We have switched it off.
There's still an echo, though.
Yes. Perhaps I should try.
Yeah.
We do have a technician here. But
That's better. That's better. I don't hear the echo now. Please start with, please commence with your argument.
May it please you.
It's back on.
The first issue is a question of condemnation. The Honorable Court will find
my understanding is that there's no opposition. I think just argue the other case.
Yes, may it please you. Then the second issue is the question of granting leave to appeal. That we deal with at paragraph 2 of our heads of argument. The test for granting leave to appeal is by this stage quite well known. It's it's set out in the case of Paulson versus Slipknot Investments, which my learned friends deal with. The three requirements are that there should be an arguable point of law, should be a point of general public importance to be considered by this honorable court, and that it is in interest of justice. We set out the grounds on which we submit this honorable court should grant leave to appeal. We set them out at paragraph 2.3 that it deals principally with the interpretation of sections 15 and 19 of the Municipal Finance Management Act. We submit that a question such as this, interpretation of these provisions, is a question that should be entertained by this honorable court. The Honourable Court will note that in the SCA judgment, His Lordship, Mr. Justice Petse, particularly dealt or stated that it was a question of legality and a question of rule of law. So we submit, if you take these aspects into account, I'm not going to deal individually with all the aspects.
Sorry, Mr. De Silva, could I ask you this question now that you are on application for leave to appeal? In your heads of argument at paragraph 3.23.3, you take the point that section 19 is not applicable as the municipality was not going to spend money, it wasn't contemplated, and therefore you say, in the judgment of the Supreme Court of Appeal at paragraph 23, page 721 of the record, the court said council was constrained to accept that section 19 fines application, but that council argued it should not apply to third parties such as private entities like Merifon. So I just need some clarity with regard to what is the appellant's position. Does section 19 apply or not? Or does it apply with limited application to bind a municipality, but not to bind third parties? I need some clarity on that because that's really the thrust of the appeal, not so.
Yes, I submit, Justice Colopin, that you're correct in your approach, that the crux of this appeal turns on section 19. We submit with respect that if you look at the particular facts of this matter, that section 19 and section 15 do not apply to this matter.
So the concession that was made in the SCA, was that incorrectly made?
No, there was no concession made with respect, Justice Colopin. The point that was made, the appellant's case has always been that section 19 does not apply. What happened in the SCA is that eventually I was referred to the provisions of section 3 of the MFMA Act. And section 3(1)A says that the act applies to all municipalities. And on that point, I had to make the concession. But irrespective of whether the MFMA Act applies to municipalities, it doesn't follow that the provisions of section 19 apply to the present case. And this was our submission in the SCA. It did not. We submit that section 19 does not, if one, and I'll deal with it in more detail presently, but we submit it does not apply to the present matter. And if one starts off, the starting point is, this Honourable Court will recall, there was the letter of undertaking, if I may refer to that letter. It was the letter written by Costa. It appears at page 35 of volume 1. In that letter of undertaking, one sees that the head of department, Mrs. Manamela, writes to the municipal manager, and she says in that letter, it's at page 35, she says, "We refer to the above mentioned transaction and hereby confirm that the department in the current financial year ending 31 March 2013 has budgeted the required 52 million, excluding VAT, required to acquire the above mentioned property." Then the letter says the funds will be paid into the trust account of the transferring attorneys after the deed of sale between the municipality and the seller has been concluded. The department will further pay the applicable transfer and registration costs amounting to 209,000. So it is clear that whatever monies were going to be paid, were going to be paid directly from the province to the transferring attorneys. So the monies would not at any stage be received by the municipality. And once
I follow that, Mr. De Silva. My follow-up question is simply that if section 19 does not apply, then how is this court's jurisdiction engaged?
Well, it's engaged on the basis that there must be a proper interpretation of section 19. And with respect, the SCA erred in finding that it was applicable. And it is important that members of the public who enter into contracts, similar contracts with municipalities, that they have clarity in this regard.
If my brother is finished, I'd like to ask you about jurisdiction, a further question. Mr. De Silva, please. Just for the moment, assuming, and I emphasize assuming in your favor that on some or other basis this court's jurisdiction is engaged, there's of course a further question, is the question of the interest of justice, whether we should hear this matter. And one of the, not determinative, but one of the important factors is the prospects of success. Now, since you have read the letter from Coxstar, I'd like to immediately take you to the resolutions that I would like to contrast with each other that the municipality has passed. But before I get there, do you accept that section 17 of the MMFA and section 15 is very clear, it's peremptory, that immovable property can only be acquired by resolution of the council and having been properly appropriated in the budget? Do you accept that as a matter of principle?
Yes, we accept that.
So there must be a clear
Majid.
resolution. And then, of course, section 19 is the one that is pertinent. Now, the MFMA also says that a council cannot acquire a budget unless cannot acquire land unless it's properly budgeted for, and the funds are available. That is clear from the MFFA. You accept that too?
Justice Majid, with respect, section 19 says that if one looks at section 19, it deals with capital projects. It doesn't deal with land. It says a municipality, if you look at section 19.1, it says a municipality may spend money on a capital project only if, and then there are the 4 requirements. So it deals with a capital project. So our starting point with respect, and I'll develop the argument, is that there's no evidence before, there was no evidence before the court or quote that this was a capital project. If you go
sorry, was the SCA wrong in finding that the acquisition of this land was in fact a capital project?
I submit with respect, yes, they were wrong. If you look at the provisions of section 19, and one analyzes section 19, when one talks about a capital project, it deals, if you look at 19.1a, it deals the money for the project, excluding the cost of feasibility studies. So one envisages a project that could possibly incur where feasibility studies are done. And then one sees in 19.1c that section 33 has been complied with. That means where a capital project goes over more than 1 financial year. It goes over several financial years. So when one considers a capital project, one envisages a project that may exceed 1 financial year or several financial years. And then if
sorry, before you go on, can I just ask you, Mr. De Silva, I'm sorry to interrupt you, but before you go on, do you accept that land is a capital asset?
I accept it's a capital asset, Justice Majid, but we
so the
do not
acquisition
accept,
of a capital asset is not a capital project?
No, with respect, no. If one looks at section 19.2, it says before approving a capital project in terms of subsection 1, the council or municipality must consider, and if you look at B, the future operational costs and revenue of the project, including municipal tax and tariff implications. And we all know, if one looks at the context of this matter, that what the purpose of buying this land was for human settlement. There was a dire need, or there still is a dire need for human settlements. So if one looks at the capital project, one would have expected that RDP housing would have been built on the land. And that would have been closed. So it's not a matter of just buying the land. It's a matter of buying the land, rezoning the land, acquiring services for the land, and building housing on the land, and possibly selling the housing. That entails a capital project. But the point I'm making with respect is that Mrs. Mashaba never testified about that. There's no evidence. If you go through the record, the mention of capital project is only mentioned twice in the record. Once when I was cross-examining her and once out of her own. But there's no evidence before the court or quo and before this court that the project, the acquisition of land, in fact, is a capital project with respect.
Well, I get your answer. I'd like to ask one last question, and this is the point that I really want to leave with is, do you accept, I understand what you're saying about the SCA judgment being wrong and in categorizing this as a capital project. Prima facie, as presently advised and having read these papers, I have a different view. But let's for the moment just turn to the record, please, volume 2. And there's two pages I'd like to refer you to. Volume 2 of the record. And the first one I'd like to refer you to is page 182. That is the resolution which is pertinent here. It's the resolution in respect of remaining extended portions 5 and 6 of Farm Mooiplaats. It's the one that you've already referred to. Well, it's referred to in the heads. I don't know if you've mentioned an oral argument so far. But it says that the commitment letter from the Department of Mkoxta, for sure, to purchase portions 5 and 6 is approved.
Yes.
Now, just turn then, with that in mind, to page 121 to contrast another resolution, also of another portion 4 of the same Farm Mooiplaats. That was for the Khakapane Cemetery. A901 on the minutes, page 121 says that council approves the purchase of portion 4 at a maximum amount of 4 million rand, and so on and so on. Now, it seems to me, Mr. De Silva, that the second one, this purchase in respect of portion 4, is a proper council resolution in terms of which land is acquired as contemplated in the MFMA. Whereas the first one I read is merely a recordal. It merely records that we've received this offer from Coxter for funds to be made available, and we approve it, we accept it, in other words. Can that ever be a proper resolution for the acquisition of land? If for a moment you assume it's a capital project, do you accept that it wouldn't qualify as a proper resolution, the first one?
We submit that the resolution in fact qualifies as a proper resolution.
Qualifies as what?
That the resolution that appears at page 182.
Yes. Yes.
And we submit with respect that in comparing 182 to the resolution at 121 is an incorrect approach with respect. We don't know what the background of the resolution at 121 was. We know from Mrs. Mashaba's evidence that there's a procedure that has to be followed. One first has to, what she did is she approached the mayor, and then she approached the executive committee. The executive committee makes recommendations to council, and then the council considers it. Now, one doesn't know what applied in regard to the resolution at page 121. We don't know what the background was in regard to the Khakapane Cemetery. So just purely producing one resolution and contrasting it to another resolution, we submit, doesn't prove anything. But what one has to consider is the procedure that Mrs. Mashaba followed. And one has to take into account the delegated authority. If you'll bear with me, where's the delegation? If one considers, if one looks at at volume 3, at page 199 and 200, the delegation is set out. And the delegation is at 755. It says, as far as the council is concerned, the council has to consider the acquisition of land and other fixed property for the municipality. So that's what the council has to do. It has to consider the acquisition of land and other fixed property of the municipality. If one contrasts that on the next page, at page 200, at 788, the authority of Mrs. Mashaba, the municipal manager, was she's entitled to sign, authenticate, and execute documents relating to the transfer or acquisition of the immovable property. So as far as the
Mr.
council,
De Silva, that's a completely different question. I'm at the first level, at the first hurdle. I am at the hurdle where only the council can consider and approve the acquisition of land.
Yes,
Now,
yes.
I get what you submit, but I don't see the difference where land is acquired of coincidentally the same farm, but land is acquired. One instance for a cemetery and the other one for RDP housing. But I will leave it there for now. I mean, I've heard your submissions. Unless you want to
Yes,
add something.
I would like to finalize my submissions, Justice
Yes.
Majid. If one looks
Certainly.
at the delegation at 755, what the council was meant to have done was to consider the acquisition. If one looks at the Oxford Dictionary of what is meant by considered, it means one must give serious thought to the question that's being entertained. It can also mean to deliberate or move a motion. That's what it means to consider. Now, one must take into account the context of what this resolution, how it was passed. And one considers Mrs. Mashaba's evidence. She says, if you'll bear with me, it's at volume 6, page 517. Now, I'm not going to belabor this honorable court with all the evidence, but it's common cause that she first approaches the mayor. She discusses the matter with the mayor. Then the matter goes to the executive council. She sits on the executive council and they approve the resolution. Then council sits and considers the matter. And she, if one looks at the resolution, the resolution at page 182, a few pages before that, if one turns to page 178, one sees all the parties that were present at the council meeting. And at 178, one can see that Mrs. Mashaba was present. And what's important about this resolution is that the resolution, the heading of the resolution reads acquisition of remaining extent of portions 5 and 6 of the farm Moy plot. And she explains what happened at the council meeting at page 517. If you go to page 1, it's the record, volume 6, at 517 at the bottom. And she says the following: yes, I had to. The item had to go to council. Then the question was asked, yes. And then she says, as indicated for consideration, that's precisely what the delegation says, 588. She says, as indicated for consideration, and my understanding of considering it means you apply your mind. It is either you approve or disapprove. And then I said, yes, did they approve or did they disapprove the purchase of land? They approved. If they approved, you know the letter. The letter was all about, you know, the purchase of the land. And then she goes further at line 10. She says, my understanding was that I need to implement the council resolution. And that's when she goes, after she sat at council and after they approved the resolution, she goes and signs the contract.
Mr. Da Silva.
All I want to say, Mr. Da Silva,
sorry, my brother.
Sorry.
Go ahead.
I just want to conclude based on the evidence that all I am saying to you is exactly what she says. All they approved was they approved the letter. They didn't approve the acquisition of land. But I leave it there. Thank you. Thank you, Justice Matlanga. Thank you, Mr.
Thank you, my brother. Mr. Da Silva, you said section 19 does not apply because the funds, I'm paraphrasing of course, were to be paid by the provincial department directly into the trust account of the transferring attorneys. Please help me with a difficulty I have, which is this. That may well have been so, but your client now is looking to the municipality and not to the provincial department for the satisfaction of that which the contract purported to provide for in favor of your client. So it is the municipality that, according to your client, is now bound. How can Section 19 then not apply? I hope I'm making sense.
Justice Madlanga,
You
Section
must,
19.
if you are going to spend, of course, I'm talking about 15 and 19. If you are going to spend money as a municipality, you must have budgeted for that as stipulated in the sections. Now, fine, the money was going to come from the provincial department, but it is the municipality that is bound by that contract. And if something goes wrong, your client looks to the municipality and not to the provincial for money to be spent. If, for example, you seek, your client seeks a specific performance, money will then have to be spent. And if for whatever reason the provincial government does not pay, your client looks to the municipality as it is doing now. And money, if your client is successful, will have to come from the municipality. Has the municipality budgeted for that in terms of the MF, Municipal Finance Management Act? It has not. So how exactly does the section, or do the sections not apply?
Justice Madlanga, the first aspect that one has to take into account is the provisions of the contract. You find the contract, if I remember correctly, in volume 8. The volume 7, I apologize. So if one goes to the contract, it appears at 642, and the relevant provision is clause 4. So one turns to clause 4, and it deals with the purchase price. So 4.1.1 says the purchaser, this is now the municipality, will on or before 29 March pay to the seller a full purchase price of 52 million to be held on the trust by the attorneys until transfer date. So in other words, it's clear that the purchaser was meant to pay the money to the attorneys, the transferring attorneys. It's in accordance with a letter that was given that I've referred to, that appears at page 5, the commitment letter, page 35. So it's couched on the same basis. So there are two aspects one must take into account. Firstly, when I say we, the appellant doesn't have a contractual nexus with the province. So we could never sue the province. In fact, initially when this matter started, the province was joined as a party and they took an exception, and we came to the conclusion it was a good exception. There's no legal nexus between us and the province, and even on the commitment letter, we could not sue the province. And this is why we sued. We had no other option other than to sue the first respondent, Greater Letaba, in terms of the contract. Now, the next question is, does Section 19 apply? And one has to analyze Section 19, and one knows that the contract was structured and all the dealings were structured based on the letter of commitment. And the letter of commitment of the 6th of March 2013 was that the province would pay directly to the transferring attorneys. Now, it's not only a question of interpreting Section 19. One must take the evidence of Mrs. Machaba, who was the municipal manager. One must take that into account as well. But I'll first deal with the provisions of Section 19. Section 19 says it applies only to capital projects. I've already made the submission. There's no evidence that this acquisition of land was a capital project.
For purposes of the debate between you and I, let us assume that it was. Because I just want to understand.
Okay.
Because what you've said thus far actually reinforces or buttresses the point that I've made. But of course, it sounds like we are moving on to the next step, which will then perhaps go against or contrary to what you have said, which thus far buttresses my point. Because I'm saying, because this was not a tripartite agreement which bound the provincial department to your client, which then resulted in your client only being able to look to the municipality. Things go wrong, and right now they have gone wrong, which is why you are here. So the short point is, if in the end your client will look to one person or entity only, which is the municipality, and if your client is seeking specific performance, and on the assumption that the specific performance is successful, where will the money come from? The money will have to come from the municipality. And if it has not been budgeted for, does Section 19 then not come into the equation? That's the simple point I'm trying to make. But of course, I thought you were then moving on to address that part of my question frontally or directly.
To try and answer your question, Justice Madlanga, firstly, let me deal with Section 19.
Yes.
I've made the submission, and you've made the point that let's accept it's a practical capital project. The section reads, a municipality may spend money on a capital project. It was put to Mrs. Mashaba, was the municipality spending money? And she said, no, they weren't spending money. So as far as that provision is concerned, Section 19 doesn't apply. Then the next, if one looks at 19.1a, the money for the project, excluding the cost of feasibility studies, has been appropriated. Mrs. Mashaba was asked on 4 different occasions, has this money been appropriated? And her answer always was, in the record, her answer always was, if we have not received the money, we don't have to appropriate it. So on those 3 grounds alone shows that Section 19 does not apply with respect.
But will the municipality not spend money now? If specific performance is successful,
well, the answer
money now.
We submit.
And is this not something that was overarching throughout from the beginning up to now?
We submit that this is a question of cooperative government. If one looks at the provisions of 35, section 35 of the MFMA, it says national and provincial departments and public entities must, it's preemptive. If you look at 35B, promptly meet their financial commitments towards the municipalities. They made a commitment to the municipality and they have to comply with it. So what should have happened is once the municipality...
That's something else though. That's not addressing Section 19. That's something else. Section, is it 41 or whatever those?
Yes, it's 35B. Justice Madlanga.
Amendment of the Constitution.
Yes, Section 41. Yes, I wanted to refer you to Section 41. It's got a very similar provision that says that the principles of cooperative government play a role.
But my point is, even before you take me there, my point was more that the question of cooperative government is totally different to what I'm debating with you now. As to what the organs of state should have done between and amongst themselves, that's a separate issue to the question whether they ought to have been budgeting as contemplated in the MFMA. Those are separate issues, and that's what I'm engaging you on.
Yes, yes, but I'm referring you with respect to the provisions of corporate governance, because you asked me the question, if, in essence, as I understood the question was, if we give judgment for the appellant now, the municipality must pay. And where's the municipality going to get the money? And my answer to you is there are provisions both in the MFMA Act and in the Constitution which deals with cooperative government. Instead of the municipality, after the administrator took a decision to cancel the undertaking to pay the 52 million, there were other remedial steps they could have taken. They should have taken these steps as soon as there was a letter of demand served on them. And it was from 2013 till now, and they haven't done anything. One would have expected, from my point of view, from the appellant's point of view, that when we sued the municipality, that they would have joined the province. They never joined the province. They could have joined the province and said, look, you gave us an undertaking. You said you would pay the 52 million. Where's the money? But the point I'm making, Justice Madlanga, is that the question with respect to ask where's the money coming from is a situation that the municipality can and should have sorted out with the provincial government and national government. It's something they could have done, and they could have, and there is mechanisms for them to do that. There's a special act that makes provision for dispute resolutions between organs of state, and all that procedure could have been followed. But the question really is not so much is must the municipality pay. The question really is that the appellant is sitting in dire straits. It has entered into a contract, and the municipality has thrown its arms in the air and said, I can't comply, which is not an answer with respect. So we submit that in fact the municipality must take the necessary steps to provide for the money. And when this court makes an order, and we'd request you to make an order in favor of the appellant, you can make an adequate order. The Constitution, I think it's section 172, says that you must make an adequate and justifiable order. This court can make an order, for example, directing the municipality to take the necessary steps to obtain the money from the province. And then you can delay the payment, say, for a period of 90 days until those steps have been finalized.
Mr. De Silva,
yes.
Just in the interests of time, if my brother has completed his questions, you accept that it's the municipality that is contractually liable?
Yes, it's correct, Justice Until.
Your argument under section 19 and 15 is, however, that the municipality is not going to have to incur expenditure or spend money, to use the statutory language, because the province will do so. That's the gist of your argument, as I understand it.
Yes.
Why is the commitment letter to which you have referred us any different from an undertaking by a bank to provide funds for the purchase of a property? And is it any different?
I submit not. I mean, my example in the court of quos, if you want to buy a car, you go to a bank and they finance the car. So third party pays the money, although you incur the obligations to pay.
Well, isn't that your difficulty? If the bank goes bankrupt, or for some other reason, having given the undertaking, reneges on the undertaking, you are left, that is in this instance, the municipality is left with the liability. And that is, you may say it's a contingent liability, but it's a liability that falls within 15 and 19 because there is a possibility that has materialized that the municipality will have to pay.
I submit with respect, Justice Unthalter, that if one takes that into account, if one compares the example that you gave, where a bank gives an undertaking and the banking goes bankrupt, nothing precludes the purchaser from going to another bank. But the point
that doesn't help your argument. The question is, was the municipality able to incur the liability? It's true that the purchaser may find alternative funding if the bank goes bankrupt, but the individual is liable in the case of an individual transaction. But here, a public entity, the municipality, can't incur the liability without compliance because it has to pay.
But with respect, the question as posed to by you, if one looks at clause 4 of the agreement, on the proposition, the way you approach it, that the municipality can't incur liability, it would mean that that contract can't be concluded.
No, it can. The question of the payment directly is simply the mechanism if the province makes good its commitment. It's just the mechanism of transfer. The banks do exactly the same thing when they fund transactions. They'll pay the purchaser directly, but it doesn't mean that they are contractually obligated to the seller.
Well, with all the due respect, Justice Unthalter, if one looks at clause 4, clause 4 clearly provides that the municipality incurs a liability. And you mentioned that there's a mechanism. Clearly, there's a mechanism for payment. There are other mechanisms available to the municipality. If one looks at for example, section 27.4 and 29, all those sections deal with non-compliance with the provisions of the chapter. 27.3 says a mayor of a municipality must, upon becoming aware of any actual non-compliance by the municipality of a provision of this chapter, inform the council, the MEC for finance, and the national...
I'm afraid you're deviating from the question that I'm asking you. You say that 19 and 15 don't apply because they don't incur any expenditure, but the fact that there are mechanisms for dealing with any failure to comply doesn't answer the question, how are they in a position to enter into this contract in the first place without compliance?
But they didn't, with the respect. You must look at the evidence of Mrs. Mashaba. She says if they didn't receive the money, then they didn't have to allocate the money. She says it at four different places.
I don't understand how that helps us to understand the legislation.
Well, with
it's a
respect
question of law. It's a question of law. If the liability was incurred, and all that the commitment is from a third party to fund it, you are incurring at least a contingent liability, and hence 15 and 19 applies. But I think I've heard your answers. I don't want to further ask questions. I'm sure my colleagues wish to do so.
May it please you, Justice.
Mr. De Silva, was it open to the applicant to plead in this case that the municipality would not have incurred a financial obligation to make the payment, and for those reasons, sections 15 and 19 are not applicable?
I'm sorry, could you repeat the question, please, Justice Theron? Was it open for the applicant, or the appellant?
Yes. If I understand the applicant's case, the applicant is saying that sections 15 and 19 are not applicable in this matter.
Yes.
Was it open to the applicant to plead why those sections why it alleges that those sections are not applicable. Because that is a somewhat different case to the case that we are dealing with. Nowhere in the papers, as far as I can tell, does the applicant say sections 15 and 19 are not applicable because the municipality was not going to incur any financial obligation.
Justice Theron, if you look at the pleadings, if you turn to volume 1,
Seems to me there's a bare denial about the legality claim that's made by the respondent.
well, the first respondent, if look, obviously the particulars of claim appear from at page 7 and further, and then the plea appears at page 25 of volume 1. And what the first respondent did, you'll find at paragraph 4. They say it was a capital project, and then they plead the provisions of section 19(1). And then they come to the conclusion at paragraph 4.6, that's at page 27. They say in the premises, the first defendant failed to comply with the provisions of section 19(1) of the MFMAA. You'll recall that there was a counterclaim, 2 counterclaims delivered with the plea, and then you'll find the replication at page 36. The applicant filed a replication, and if you turn to page 41, it was pleaded by the applicant at paragraph 8 in amplification of the aforesaid denial, and without detracting from the general nature of the plaintiff pleads that first defendant is specifically put to the proof thereof that the provisions of section 19 applies to the agreement. So that was placed in issue, squarely placed in issue by the applicant.
Mr. De Silva, my question is a little different. Was it pleaded by the applicant that enforcement of this agreement would not result in any financial obligation on the municipality? Because that is what I seem to understand the applicant saying, is that because no money was being paid from the coffers of the municipality, sections 15 and 19 are not applicable. Was that pleaded? Because that is a slightly different case from what has been pleaded before us, that those sections don't apply, but we're not given a reason why. From my understanding of your case, it would appear that your argument as to why those sections don't apply is because the money was coming from the province. So my question, and I repeat it, was it pleaded that sections 15 and 19 do not apply because enforcement of this contract would not result in any financial obligation on the municipality?
Justice Theron, to answer your question, as you put the question, it wasn't specifically pleaded, as you suggest, but we submit with respect that if one looks at paragraph 8, we say that section 19 does not apply to the agreement. We say the first respondent is put to the proof thereof that section 19 applies to the agreement. And a denial, the legal position.
And the respondent has come to court. The respondent has said, section 19 applies. We have not budgeted for it. The agreement is not valid. Is that not the end of the matter?
Oh, sorry,
I submit with respect.
I thought you were done with the question. Sorry, my sister. Before you respond, Mr. Da Silva, your time is up. I do realize, of course, that you had hardly had a foot in, and we started putting questions to you right away. That notwithstanding, how much more time do you want? I know as counsel too, when I argued before this court, you would feel that you've actually touched on everything you wanted to argue on, but you would have done so very haphazardly, and you would feel, I've been hard done by, but you can't go back and start from the beginning and go all the way down.
Yes,
but
I realize that, Justice. Could I have 15 minutes, please,
15.
Justice Mhlanga?
I will give that to you. Please respond to Justice Theron.
If I well, the point I've made, Justice Theron, to try and answer your question, is that the applicant has clearly placed the provisions of Section 19 in dispute, and by placing that in issue, the applicant could have dealt with any issue dealing with Section 19. We specifically pleaded, we say, is specifically put to the proof that the provision Section 19 applies to your agreement. And we submit, it's like a denial. If a party denies something, you can lead any evidence to support the denial. And under these circumstances, I submit with respect that the applicant was entitled to raise the point that Section 19 was not applicable.
Wouldn't there then have been an evidentiary burden on the applicant?
No, with respect not. With respect not.
Can I finish my question, please, Mr. De Silva?
Certainly.
Wouldn't there have been an evidentiary burden on the applicant to lead evidence to show why the applicant is seeking to enforce the contract, to show why sections 15 and 19 did not apply? Wouldn't the applicant have had to show that enforcement of this contract would not attract financial liability on the municipality that has not been budgeted for?
Justice Theron, the answer is as follows. The well-known case that deals with the burden of proof is Pillay versus Krishna. It's the appellate division, it's 1946, appellate division at 946, where Judge Davis dealt with the burden of proof, and he sets out the different rules that apply to burden of proof. And what Justice Davis said in that case is that if a defendant raises a special defense, he is in the same position as a plaintiff. He has to prove his case. And this is precisely what the...
In the interest of time, let me break it down, Mr. De Silva. The defendant, first respondent, municipality has come to court. Municipality has said, we, the municipality, did not budget for this expense. If there is no further evidence from the applicant, is that not the end of the story as it relates to Section 15 and to Section 19? Wouldn't it then have been for the applicant to take it further? Once the municipality has led that evidence, or the municipality says we have not budgeted for it, wouldn't then it be for the applicant to show that either they've budgeted, the municipality has budgeted for it, or if sections 15 and 19 are not applicable, why they maintain it's not applicable? Because the municipality would not incur any financial obligation that it has not budgeted for.
Justice Theron, if one applies the principle set out in Pillay versus Krishna, Pillay versus Krishna specifically said that if a defendant raises a special defense, then it bears the burden of proof. It's quite clear from the pleadings. If you look at paragraph 4 of the plea, that's at page 26, volume 1, that the defendant...
And ask the question one more time. I understand what Pillay versus Krishna says. And my proposition to you is, once the defendant comes to court and the defendant says, in this instance, the municipality says, we did not budget for this amount, what more must the defendant do?
The defendant must show that Section 19 is applicable. The defendant must show that it's a capital project. The defendant must show that it received money. The defendant must show that the money that was received was allocated to its budget. The defendant has not shown any of those propositions. The onus is not on the plaintiff. The onus is on the first respondent. With respect, it's raised a special defense.
Thank you, Justice Malanga.
Thank you, Mr. Sister. Please continue, Mr. Silva.
May it please you. I've dealt with section 19 to a large extent. The next aspect that I submit I should deal with is at page 22 of the applicant's heads of argument. It deals with the implication that if this honorable court had to find that section 19 is applicable, we say that the formulation as set out, I'm at paragraph 5.2 of the applicant's heads of argument. We say that the formulation in Skirot is incorrect. We submit with respect that as set out in Liebenberg versus Berg River Municipality, that is the approach that this honorable court should apply. Then at paragraph 5.7, we refer to the Metro Western Cape case, which dealt with certain non-compliance of a statute provision, and what was taken into account was that innocent parties such as the applicant's position should be taken into account. And then we make the submission at paragraph 5.8 that a further consideration that should be taken into account is the principle of pacta sunt servanda in this matter. And then we refer to different provisions of the MFMA Act, which we say provides for further remedial measures, such as I've already referred to section 27.4 and section 29. And then we make the submission at paragraph 5.16 that if the Act, the MFMA Act, intended the provisions of the Act to visit a nullity on the contract we submit, it should say so specifically, and we refer as an example to the Public Finance Management Act. If one looks at section 68 of the Public Finance Management Act, it specifically provides that if certain provisions of the Act are not complied with, then the Act is a nullity. And we submit with respect that there are no such provisions in the MFMA Act, and that it was not the intention of the legislature at any time to visit nullity upon this specific contract. Then at paragraph 6, we deal with the question
what does contract props say in that regard? Does it not say you look to a few factors, one of them being even the purpose or the object of the Act or provisions? And in that case, it was about government procurement. And the issue was whether if you've not gone through the tender board, shouldn't that be visited with invalidity? And the court said, yes, it should, because they said the interposition of a tender board is to make sure that there's no patronage. And the court even says open quote or worse, close quote. And then they said, if there has been non-compliance, invalid. So the fact that there's no provision that the result will be invalidity does not necessarily mean that that will result in validity. Yes. So the short point is why don't you grapple with the contract props approach?
Yes, I submit that you're correct. There are different factors, and this is what I've tried to point out, Justice Madlanga. If one looks at our heads of argument at paragraph 5, for example, we say one looks at at section 27.3 and then one looks at section 29 and one takes all those factors into account. And if one takes into account there are remedial provisions in section 35 of the MFMA Act, all those factors we submit point to the fact that it wasn't the intention of the legislator to declare the provisions invalid.
To visit non-compliance with invalidity.
Yes, may it please you. Then we deal with estoppel at paragraph 6. We say the well-known case of the city of Tshwane versus RPM Bricks. We say that the conduct of the municipal manager falls into the second category, where the irregular or informal, the exercise of power. And so we submit with respect that estoppel should be applicable in this matter. And then our final argument is the delay. We submit that in essence what the first respondent seeks is to review the decision or review the contract, and we submit that there's been an inordinate delay. It's been a delay of 4 years. You will note in our heads of argument at page 35, at footnote 74, there's a reference to Camps Bay ratepayers versus Harrison. In that decision, it's a decision by this honorable court. In that decision, Justice Brandt found that a delay of 3 years is an inordinate delay. So in this case, there's been a delay of 4 years, and we submit that it's not an aspect that should be pleaded. It's an aspect that a court can take mero motor. And then we have our conclusions at paragraph 8. And those, if I can just ask my learned junior if there are any other submissions, those are my submissions. May it please you. Yes. Oh yes. Okay. There are 2 points that I wish to make. The one is in an attempt to answer the question put to me by Justice Unterhalter is of when the contractual obligations arose. We submit with respect that one must determine that on the date of the contract, being the 7th or the 22nd of March 2013. Whatever happened afterwards is something else. And what is important is that just Mrs. Mashaba, when she testified in her testimony, and it was put to her that the funds were not allocated, she said it could have been done in further financial years. So this is an allocation that could take place at a later stage. And then the last submission I wish to make is, as far as the costs are concerned, we submit that the principles set out in the BioWatch matter are applicable. This is a private individual that's litigating against an organ of state. There are several organs of state that play a role, and we submit that the correct cost order would be, if this honorable court has to find against the applicant, then this honorable court should find that each party should pay its own cost. And that includes the costs of the court quo and the SCA's costs. I have no further submissions, unless there are questions that are posed by this honorable court.
Mr. De Silva?
Understand, yes.
Yes, thank you, Justice Mhlanga. Mr. De Silva, I would like to explore, one of the questions I'd like to explore with you is interest of justice that was touched on by presiding judge, Justice Mhlanga, as well as Justice Majid. Why would it be in the interest of justice to grant leave to appeal in this matter with specific reference to contract props, which my brother presiding has referred you to? Don't those cases settle that the state is entitled to raise invalidity as a defense to enforcement of a contract? And where that happens, the only question then to be determined is whether, as a matter of fact, the council, the municipality in this case, had complied with sections 15 and 19. And does that lead us to a constitutional question? Yeah, we may have jurisdiction, but is it in the interest of justice for the court to determine a question of fact?
Justice Theron, our submission is it is not simply a question of fact, as Justice Unterhalter pointed out, that the way he approached it, he says it's purely a question of law. I submit with respect, it's a question of law and a question of fact. And it deals with the interpretation of section 19. And it's important, although this honorable court is faced with this case, I am sure that there are hundreds of contracts concluded with municipalities every year. And there should be certainty in regard to how one interprets section 19. And if one approaches it from that point of view, then I submit with respect that it is in the interest of justice that that this matter should be entertained by this honorable court.
Why do you say there is any uncertainty as to how section 19 should be interpreted or applied? Or are there differing cases emanating from some of the courts on the interpretation and application of section 19?
No, I'm not aware of different decisions on section 19, Justice Theron. But the submission that we make is that section 19 is not applicable. We submit with respect that the provisions haven't been complied with. There's no evidence to show that they've been complied with. We submit, if one takes into account how, and I say this with the utmost respect, Justice Pitts in his judgment in the SCA said, well, the provisions are clear. But we submit with respect that if one looks at the facts, that is not so with respect, and it's in the interest of justice that that a judgment should be given by this court dealing with section 19.
Now, doesn't this court and any other court as well find itself in the difficult position that it cannot give effect to an illegality? And this question, let's assume that section 19 applies. Yesterday, this court handed down judgment in the matter of Nehau versus the Minister of Public Service and Administration, and that principle was against enforced in that matter.
Well, there are two legs to the answer to your question, Justice Theron. The first is obviously the answer. We say section 19 doesn't apply. Then the second leg is if this honorable court has to find that in fact it does apply, we submit that a proper interpretation of section 19, a proper interpretation of the legal framework of the whole act was not to visit nullity upon the contract. So that in itself, as the court of quo found and Justice Pitts in the SCA, that in itself is something that this honorable court should determine and to bring certainty in this legal sphere. And we submit with respect that that is in the interest of justice, why this court should entertain this matter. Respect.
If I understand your submission, Mr. De Silva, when you talk about not visiting nullity, it may well be that we are going to section 172 and the power of this court to grant just and equitable relief. Am I understanding you correctly?
Yes, yes, Justice.
So it may be as a legal consequence, the contract is null and void, but this court has a discretion having regards to the circumstances of the matter to make a just and equitable order. And that leads me to the final aspect I would like to discuss with you. On the papers, this contract was concluded either on the 7th or the 20th or 22nd of March. As early as April, the applicant knew or ought to have realized there was a difficulty or there was a challenge with enforcement of the contract. Is that right? April, May of the same year.
Well, it's the date of when the letter of demand was written. One has, in volume 1, one has the letter of demand. Ladyship or
Wasn't it in April? Wasn't it in April that the letter?
Yes.
23rd of April.
Yes.
So a month after the conclusion of this agreement, the applicant was aware that there were challenges with the enforcement of this agreement. Yes?
Well, that is correct, Justice Theron. I assume there's a further question that's going to follow, but the point I want to make at this stage is that there was a contract in place. There's a valid contract in place seen from the applicant's point of view.
Yes, Mr. De Silva, we're dealing now with the question of just and equitable remedy.
Yes.
One of the factors that weigh upon the court in deciding what an appropriate remedy would be in these kind of circumstances is to look at the question of prejudice. In May, the municipality wrote to the applicant, and this is at page 187 to 188 of the record. I must say the letter is slightly confusing, but it is mentioned in that letter that the agreement was concluded on condition that the municipality would receive finance and funding from the department.
Justice Theron, you're referring to page 187. That's a letter dated 2nd May.
That's correct.
Yeah, paragraph 2 deal says, we're in agreement with you on condition that the department, but this doesn't appear from any of, well, it doesn't appear from the contract with respect. This is a supposition that Ms. Mashaba, the municipal manager, says. But if there was any condition, it should have been contained in the contract, and that's not the case with respect.
The only point I'm making, Mr. De Silva, once again, it goes to possible prejudice.
Yes, yes.
And where a party is alerted a month, 2 months after the conclusion of the contract, that there is a challenge in enforcing this contract, what legitimate prejudice can that party suffer? Well, let me rephrase the question. What attempts were made? What has the applicant done to enforce the contract? Sorry, let me rephrase it. What has the applicant done to perform in terms of the contract? Because wouldn't that be a measure, a yardstick to measure possible prejudice that the party has suffered?
Well, to enforce the contract, if I remember the particulars of claim correctly,
to perform.
We tender performance. We've always tendered performance. We say, we have the land, we tender the land, please pay the purchase price. So we've always tendered performance.
So how would you quantify or explain the prejudice that the applicant has suffered by reason of the non-performance of the municipality? And how is that articulated in the papers? Because I had some trouble trying to identify that in the papers.
It's not articulated at all in the papers. This is not an issue that was ever raised.
Isn't that a difficulty for the applicant? When it comes to a just and equitable relief, which this court must fashion, if the applicant does not come to the court to say, we understand there could be a problem, but we plead with this court to invoke its powers under section 172(1)(b), because if it does not, this is the prejudice we will suffer. We were an innocent party. We relied on the representations that were made to us. And where the applicant does not do that, how can this court then come to the assistance of the applicant?
With respect, Justice Theron, when this case started in 2013, or when it started, we never ever envisaged that we'd be in the Constitutional Court and that Section 172 would be applicable. We never ever envisaged that we'd be faced with this situation and that we'd suffer prejudice. To answer your question whether the applicant has suffered prejudice, there's nothing on the papers. And if I had to make any type of submission to this court, it would be speculation. I really don't know. One doesn't know what other parties are available that would be able to conclude the same contract. In fact, the land has been zoned for RDP housing. I would believe, with respect, that there wouldn't be another purchaser that would be able to purchase this land. And that in itself is serious prejudice. But at the same time, when I make this submission, I do it with a measure of trepidation because I know it's speculative. This issue was never raised on the papers, and nowhere was it ever raised, with respect. We never foresaw that we'd end up in the Constitutional Court and that Section 172 would be applicable.
Thank you, Mr. De Silva. Thank you, Justice Mhlanga.
Thank you, Mrs. Chair. Thank you very much, Mr. Da Silva. Colleagues, Mr. Rousseau promised me that he would take only 15 minutes, but knowing my colleagues as well as I do, I think it will go far more than the 15 minutes. But let's just start with his argument, colleagues, and see how it goes. Mr. Rousseau.
Justice Mhlanga, members of the court, may I first be permitted just to make a few corrections in our heads of argument. The first one is on paragraph 150.
If it's typos, if it's just typos and small editorial issues, don't bother with that, Mr. Rousseau, unless it's matters that go to substance.
Yeah, just in paragraph 115, the word should read sphere. And then in paragraph 115, where we deal with a situation where a party deals, for instance, with a municipality, where we refer to the matter of S versus de Blom. In other words, where you deal with a specific entity and you know or should know that there are certain rules and regulations applicable, you cannot simply say, well, because of ignorance of the law, I am innocent. And in this regard, we want to add to the heads to say that all statutory provisions are published. And in terms of the Systems Act, sections 59 to 65 deal with delegations. And in terms of section 160, sub 7 of the Constitution says that all meetings of the municipality will be open to the public. So there is not a situation where a person can claim that he is completely innocent when he deals with a municipality. Regarding the first...
Colleagues, please remember you may put questions to Mr. Rousseau right away. Please continue, Mr. Ross.
As I understand the applicant's argument, they say that because the province would pay the seller directly, that the province would not pay the municipality and then the municipality would pay the seller. Therefore, Section 19 should not be applicable. This is the factual matrix that we are dealing with. But if one looks at the Act, it is very clear that if one receives money from the province, it has to go through the municipality's books. And this is one of the objectives of the Act. It says the object of this Act is to secure sound and sustainable management of the fiscal and financial affairs of the municipalities and municipal entities by establishing norms and standards and other requirements for inter alia budgetary and financial planning processes, and the coordination of those processes with the processes of organs of state and other spheres of government. So when one deals with the budget, you can only include an item in the budget if you know that the money is forthcoming. That money is for the municipality, not for the seller. And if we look at Section 18 of the MFMA, Section 18 clearly stipulates an annual budget may only be funded from realistically anticipated revenues to be collected. Then we refer to Regulation 10. And we refer to Regulation 10.2 of the Treasury Regulations. It says, realistically anticipated revenues to be received from national or provincial government, which is applicable in this case. National or provincial public entities, other municipalities, municipal entities, donors, or any other source may be included in an annual budget. And there's the proviso, only if there is acceptable documentation that guarantees the funds. Not a VBS bank guarantee. Acceptable documentation is constituted by A, in the case of allocations or transfers from national or provincial government. And then there's a list. The latest available gazetted allocations or transfers to the municipality following the approval of the current year's Division of Revenue Act, National Annual Budget, National Adjustments Budget, relevant provincial annual budget, or provincial adjustment budgets. So there must be acceptable documentation. There was no acceptable documentation. There could never have been any acceptable documentation because the provincial treasury simply did not approve of this transaction.
Mr. Rousseau, I just want to understand juristically where exactly we peg the regulations. I'm asking because this is about an interpretative exercise. We are interpreting what's required in terms of provisions of the MFMA. Yes. And legal principles are to the effect that you cannot use regulations to interpret an act. So what I'm trying to establish is, in the context of the interpretative exercise, that is interpreting the provisions of the act, how exactly do we factor the regulations?
The regulations, Justice Maglanga, emanates from Section 18 of the Act. Section 18 of the MFMA says, an annual budget may only be funded from realistically anticipated revenues. Now, what do we have in this case? Did we have, or did the municipality have, a realistically anticipated revenue in the sense of a payment in the amount of 52 million rand. They didn't have that. The regulations only put some flesh on this section. It says, well, what is a realistically anticipated funds? When would you know you have a realistically anticipated fund that could be included in the budget?
So if I understand you correctly, because I don't want to lose you, if I understand you correctly, you are at this point not engaging in an interpretation of what is and what is not required by sections 15 and 19. You are talking more, do you or do you not have the funds and so on, and then you look at section 18 and look at the regulations that elucidate that. So you are not at the level of an interpretative exercise as to what sections 15 and 19 require or do not require.
Yes,
that's not where you are.
Yes, I am at the interpretive portion of the argument. They say, as I understand their argument, they say that because province would pay the seller directly, they would pay their attorneys directly. Therefore, the municipality never had to spend any money. The municipality would not have incurred any funds, and therefore they did not have to include it in the budget. But if they read the Act clearly says if you do receive money from a province, you must include it in the budget only if you have the necessary proof that the money will be forthcoming. If the money is not forthcoming, there is no budget for that particular item. That is what the Act says. So their interpretation of the Act or their application of the Act to the facts of this matter do not really help them. The Act clearly says that money is the money of the municipality. The municipality must budget for it. They are going to receive it and they have to pay for it. As is clearly demonstrated in this case, because the municipality is sued for the 52 million, not Costa. It is their liability. The second issue that we want to raise...
Mr. Rousseau,
Sorry,
before you move from section 18, I'm not sure section 18(1)(a) is applicable to this matter. If revenues to be collected, does that not refer to levies and rates and things that is levied by the municipality, and in preparation of their budget, they anticipate this is the amount we will receive from collections?
Yes, Justice Tron, with respect, if one looks at the regulation 10(2)(a), it clearly states what is realistically anticipated funds. And in this regulation, at the bottom it says, this regulation is intended to give effect to section 18 of the Act and must consequently be read in the context of that section. Regulation 10(2)(a) clearly gives the necessary guidance as to when funds should be included in the budget or not. And it does not only include revenues. It says realistically anticipated revenues to be received from, inter alia, the provincial government may be included in an annual budget only if there is acceptable documentation that guarantees the funds from the province. Acceptable documentation is constituted by, in the case of allocations or transfers from, inter alia, a provincial government. So when would a municipality know that the provincial government is going to pay this money for them to include it in the budget?
This brings me back to the question asked by Presiding Justice Madlanga. Section 18(1) and 2 does not make any provision for funds promised from the provincial government in the budget, but the regulations do.
The regulations do, but what regulation 18(1)(a) says, realistically anticipated revenues.
Yes, I understand what it says, Mr. Rousseau,
Yes.
The point I'm making is that that is not covered in the Act and which is to take precedence. In section 18, 1 or 2, there is no mention about funds that may be received from the provincial government. And my understanding of 18.1a, which you seem to rely on, is revenues to be collected. That is something very different from an allocation from a provincial department or government.
Yes, Justice Theron, if we could give revenue a very wide meaning, obviously it's any kind of revenue, any money received from whatever source.
Yes, I'll make a last statement and leave it and take it no further. Section 18.1a says realistically anticipated revenues to be collected, and one can add on there by the municipality.
Yes.
Thank you, Mr. Rousseau.
Yes, if I can just add to that. So if there is a donation by a province, let's say, for instance, like in this particular case, Costa promised that they would pay the 52 million. Whose liability is that at the end of the day? At the end of the day, it is the liability of the municipality, because the municipality concluded this agreement with the applicant. The municipality has obligations in terms of this agreement towards the applicant in the amount of 52 million rand. Now, how is one going to record that transaction in one's books? It has to go through the municipality's books. So if the expenditure has to go through the municipality's books, the municipality had to budget for that expenditure. And that is the principle of sound financial management, which is one of the objectives of the Act. There must be proper bookkeeping, and a liability must be recorded in the books. Here we have a liability of 52 million rand, which is not recorded in the books. It's not recorded in the books because the municipality said, well, we were not liable. We are not liable for the payment of the 52 million rand. And in my respectful submission, the word revenue should include any type of revenue, whether by way of taxes and levies, donations, allocations, whatever the situation might be. Any type of revenue should at least be included in the budget, because, and it, with respect, makes a lot of sense. If revenues is to be expected from a provincial government, for instance, 300 million rand, and you want to spend the 300 million rand in the next budget year, you have to budget for that. And to include that 300 million rand in the budget, you must at least be sure that that 300 million rand is forthcoming. If it is not forthcoming, you cannot include it in the budget. So in this context, Justice Strong, we say that if one has regard to all the provisions of the Act, not only the provisions referred to by the applicant, but all the provisions, it is clear that the present factual situation that we have here, where Costa promised the money, should have been included in the budget. It was never included in the budget because Costa wasn't interested in this transaction. The provincial treasury said, we're not going to pay this money.
Sorry, Mr. Rousseau, if my sister is complete.
I'm sorry.
May I ask?
I thought, was it not my brother, Justice Unterholter, wanted to come in, or was it you, Justice Kolaben?
I'm not sure.
Go ahead, my brother. Please go ahead, my brother.
Thank you. Just briefly from my side, Mr. Rousseau. Mr. Rousseau, there's been much debate about the applicability of Section 19. And it does seem that the Act makes a distinction between capital assets and capital projects. For example, Section 14 speaks of the disposal of capital assets. And it would appear that the High Court, as well as the SCA, the point of departure there was that a capital asset may well have been equated with a capital project, even though there's a distinction between the two, and it may well be arguable that a capital project is something that is based on the acquisition of a capital asset, and it's the exploitation or the use of that capital asset that would then morph into a capital project. If we should find that section 19 may not be applicable for that reason. Would you say that the argument based on illegality then would rest purely on section 15, and that that argument could be advanced with equal force? Or does the exclusion of section 19 from the equation, as it were, if we should find that, weaken the argument of section 15, because section 15 is a general prohibition as opposed to section 19, which is a specific prohibition?
Yeah, Justice Colopon, I'm not quite
Colleagues,
sure whether I followed
Mr.
your
Rousseau,
question.
Mr. Rousseau, I'm sorry to stop you mid-sentence, and apologies to you too, my brother Justice Colopon. I suggest that we take the adjournment now. You will respond when we come back, Mr. Rousseau, and let's resume at 11:45. Court adjourn.
As court pleases.
Court will now adjourn until 11:45. Please note that during the adjournment, you are welcome to switch off your video and mute your microphone, and then rejoin with video and sound when the hearing recommences at 11:45. Should you exit, you may use the same link to rejoin the hearing.
waar is ek nou? Nou is ek weg, Koos. Heerlikheid. Maar kom op.
Are my colleagues, justices, oh, thank you. Yes, Mr. Rousseau.
Justice Colopin, if one only looks at section 15 of the Act, and if we accept for argument's sake that this project was not a capital project, but merely an asset, as I understand your question correctly, then the question is, will section 15 be applicable and will it assist the first respondent in this matter? My respectful submission is that it does, because it says a municipality may accept where otherwise provided in the Act, incur expenditure only in terms of an approved budget. That's any expenditure in respect of assets, running expenses, or whatever the nature. And two, within the limits of the amounts appropriated for the different votes in the approved budget. So if a capital asset is not approved in the budget, then that expenditure will not or cannot be incurred.
Thank you, Mr. Russo. Would it matter at all if at the time that the municipality took a decision to enter into a contract, it may have subjectively believed that it was not going to have to incur any expenditure because of the letter of commitment, and that factual situation only arises later when Treasury says, no, you can't proceed with the deal. And it's at that point in time, later down the line, that the reality of incurring expenditure sort of kicks in. Would that affect the question of legality? And could it be argued that at the time of contracting, there would be no basis to conclude that the contract was illegal, but that would arise at a later stage?
Justice Colopin, my respectful submission is that it would not matter. It is a subjective view of a municipal official, and that cannot change the clear wording of the Act and the intention of the Act.
Thank you, Mr. Russo.
Then, regarding the issue of a special defense, if one looks at the particulars of claim, they say, and that was the case in the High Court, they categorically alleged that the municipal manager had ostensible authority or she had actual authority. That was their case. And as a matter of fact, if one looks at the letter of demand attached to the particulars of claim, they say that section 19 has been complied with. They say it. And the court will find it in volume 1, page 21. Now, this is the letter of demand. It starts on page 20, and then it says, paragraph 2, Letaba properly complied with section 19 of the Local Government Municipal Finance Management Act. Our respectful submission is their case was there was proper authority or ostensible authority. What the defendants did was simply to deny that and to give the reasons for its denial. It's not a special defense. It is a full frontal attack on that allegation made in the particulars of claim. So they had to prove actual authority or ostensible authority. And we've dealt with ostensible authority, the Makate judgment, extensively in our heads to say, well, the Makate judgment, ostensible authority can never fly in a case like this. Because at no point in time did the Act or the municipality or the municipal council gave the impression to the world out there that a municipal manager has the authority to conclude written agreements on behalf of the municipality. So the whole issue of ostensible authority cannot fly. And it's and uncontroversial legal principles that have been laid down in the McCarthy judgment. And if we apply those uncontroversial principles to this particular case, then that is the end of ostensible authority. As far as actual authority is concerned, we simply say, well, the act is clear. And the principle of legality, which is an incident of the rule of law, forbids any court to enforce an illegal contract. So we say that in the particulars of claim, they should have made out the constitutional issue in the particulars of claim, in their case in the High Court, which they didn't do. They knew about Section 19, they knew about the provisions of Section 19, and they should have at least alleged that Section 19 and Section 15 are not applicable for this reason or that reason, or alternatively, that that these sections are not applicable, it is not a capital project, or whatever the situation is. And as far as the capital project is concerned, Justice Colopin, this is clearly a capital project. This is not a statute that was bought by the municipality, that you only need to maybe wash once a month or whatever. Housing, the housing will be transferred to the municipality. The municipality will then transfer those houses to the people who bought the houses. There has to be provision for water and electricity for many years to come, sewage removal, waste removal or refuse removal, etc., etc. So it's a whole project. It's not something that you simply buy and you itemize it in your asset register. And
I understand the point you're making, Mr. Rousseau. All I was saying is that one could divorce the acquisition of an asset from the development of a project. And yeah, it would have been contemplated there would be a project, but the argument may well be that for now it was simply the acquisition of an asset. But I think you've responded to that. Thank you.
Yes. And we've also dealt with the issue that there cannot be any innocent persons involved in a case where you deal with a municipality or the province or with the government. And that is what the case of S versus de Blom says. It was, and I'm referring to page 115 of our heads, where we say that in S de Blom it was stated that the person who involves himself in a particular sphere should keep himself informed of the legal provisions which are applicable to that particular sphere. And such a person cannot rely on the excuse of ignorance of the law. And then that basically sums up the rest of it, or the rest of the arguments are contained in our heads. I think they are rather complete, and we persist with the points made in our heads. Justice Matlanga, as a co-president.
Thank you very much, Mr. Rousseau. Mr. Da Silva.
I please you. There are three issues.
I'm very sorry, Justice Matlanga. This went too quick for me. And I thought there might be questions from my colleagues before I jump in, if I may.
Yes.
Thank
yes,
you.
Please.
Mr. Rousseau, when did the municipality for the first time alert the applicant that there was an issue or there was a legality issue relating to the contract?
I don't have the answer off the cuff, Justice Theron, but at the very latest, I think when we filed the plea.
That would have been 4 years later, Mr. Rousseau.
Yes.
Is that acceptable conduct on the part of an organ of state?
Justice Theron, if we have a look at all the participants here, obviously all of them believed that they were in the right. The HOD thought that she was in the right. The applicant thought that he was in the right. And as far as the municipality is concerned, I assume that when the municipal manager signed the agreement, there was at that stage some discussion surrounding that. But at the end of the day, there was no decision taken by the municipality to purchase this property. There was nothing.
My question, Mr. Rousseau, is that acceptable conduct on the part of a municipality to enter into a contract in 2013, to sit back for 4 years, and then in 2017 to raise a defense of illegality? Is that fair towards the other party who has contracted with the municipality?
Yes, Your Ladyship, if one looks at what the applicant does, the applicant was of the view that Section 19 was complied with. That was their case. They said that they had actual authority. And obviously, like in any litigation, Your Ladyship, you know, when a defendant reaches the doors of the attorneys, then obviously the attorneys look into the matter. These people are not necessarily, they're not all lawyers. They're trying to do their level best. And maybe they were under the impression that there was indeed an agreement. And when they consulted with the lawyers, they got a different answer. So
does that appear from the papers, Mr. Rousseau?
No.
That the municipality was under the impression they had concluded a valid agreement with the applicant, and it was only 4 years later, when they were at the doors of the court or of the attorneys, as you put it, that they realized this was an illegal agreement. What is the explanation from the municipality for only taking action 4 years later? What explanation have they put forward?
I'm not aware of any solid explanation, Justice Tron.
Didn't this court in Kumalo say that where a municipality seeks to set aside their actions on the basis of illegality, it must be done within a reasonable time? Where there has been a delay, there must be an explanation from the municipality for the delay.
Yes, Justice Tron, that is indeed correct. But in this particular case, nothing had to be reviewed. Nothing had to be set aside. There was no decision that had to be set aside. The council didn't take any reviewable decision. As a matter of fact, they took no decision at all. It was
this is the contract that the municipality seeks to have declared, to be declared null and void.
That is correct, Justice Tron.
So that is the circumstance that I'm applying to.
Yes.
Is it fair for an organ of state or a party such as the first respondent, a municipality, to conclude a contract with the party and to sit back for 4 years? This court's jurisprudence has held in those circumstances, the party concerned, the municipality, the organ of state, must act within a reasonable time. And if there is a delay, they must put forward an explanation for the delay. The municipality in this matter is represented by competent, capable attorneys and counsel. And one has to ask why, even at this stage, there is no explanation before this court for the delay.
Yes, Your Ladyship, Justice Tron, the delay, they didn't delay anything. There wasn't simply a delay in asking for because what the municipality is asking in the counterclaim is simply a declarative. They're not asking for something to be reviewed and set aside. The decision, if there had been a decision, that decision would have been taken by the municipal council. That decision is probably a reviewable decision.
Yes, we are playing with words. The effect of what the municipality is asking is to set aside a contract that was concluded between the municipality and the applicant.
Yes, Justice Tron, that...
And my question remains, I won't repeat it, but there is 4 years later from the municipality who is represented in this matter, no explanation for the delay, no explanation why it did not act reasonably. Yes. So why should a court come to the assistance of the municipality? Why shouldn't this court say, we do not have an explanation from the municipality? It is not okay. It's not in order for a party such as the municipality to come 4 years later with no explanation and to say, we throw our hands up, the contract is invalid because we didn't comply with sections 15 and sections 19, end of story.
Yes, Justice Thorne, if we look at the papers, it wasn't necessary for the municipality to bring a counterclaim. If the applicant had instituted the action based on a valid and binding agreement, and the finding at the end of the day was there was no valid and binding agreement, then that is the end of the story. The counterclaim is merely there to have clarity as to whether this agreement is valid or not valid. But it wasn't really necessary to bring a counter application. 1, 2, there was nothing to review. 3, there was nothing done by the municipality, by the municipal council.
Let me ask the question slightly different. In view of the inaction of the municipality, well, let me not even say inaction, because you say there was nothing the municipality should have done. So if we just look objectively at the circumstance, when this court, if it comes to that point, has to consider whether it should make a just and equitable order if it finds that the contract was not valid. Why should the court not take into account in favor of the applicant that the applicant has waited 4 years before the respondent says we cannot perform and enforce this contract because it's invalid? Why should that not be a factor taken into account in favor of the applicant?
Your Ladyship, Justice Thorne, then for the very same reason, the actions of the applicant should also be taken into consideration. They knew when they concluded this agreement. They initially said that Section 19 was complied with. They knew that Section 19 was not complied with. They persisted with a claim for many years. They knew that there was no, at some point in time, they realized that there was no budget. They knew there was no authorization by the Treasury that this amount should be spent, but they persisted with that action.
That same knowledge can be imputed to the municipality. The municipality knew it had concluded an agreement in terms of which the cost of that agreement was not budgeted for. Was there a duty on the municipality to approach the court as soon as it knew to say, we want to set the record straight. We are taking matters into our own hands. We made an error in concluding this contract, and we want the court to declare that the contract is invalid.
Yes, Justice Thorne, with the greatest of respect, I respectfully submit that there was no duty on the municipality. What the municipal manager did, she didn't take a decision. That was the executory part of a decision that was never taken. The municipal council, if the municipal council had taken that decision, and if the municipal manager had signed that agreement, that was—
I'm sorry to interrupt you, Mr. Rousseau. We are at odds. What the municipality did was enter into a contract. It entered into a contract without complying with Section 15 and Section 19. Does good governance not compel the municipality in those circumstances to come to court to say, I want to play open cards with the court and with the other side? Excuse me. And to say, we as the municipality made an error. We did not comply with Section 15 and Section 19. Now, we must look at this in a situation as it affects the entire country, as it affects parties in the position of the applicant. And we're striving here towards good governance in our municipalities.
Yes, Justice Thorne, in the first instance, we refer to our case referred to in paragraph 121 of our heads, where we raised the issue of illegality. And secondly, Justice Theron, is that the municipality did not conclude the agreement. It was the municipal manager, not the municipality. The municipal manager made a mistake. She could have thought that she had authority to conclude this agreement, but the municipal council never made that mistake. So the municipality is with respect innocent. It is the municipal manager that is the guilty party here. And with the greatest of respect, the municipality cannot be lambasted for acting as it did.
Thank you, Mr. Rousseau. My question remains unanswered, but I won't ask it again. Thank you, Ms. Justice Mhlanga.
Thank you, my sister. Are those your submissions? Yes, I think it was. Thank you very much, Mr. Rousseau. Mr. Da Silva?
May it please you, I have 5 short submissions. This honourable court will recall that my learned friend referred to section 18 and then regulation 10, regulation 10.2 in his argument. I submit with respect that one must look at the factual matrix of how this transaction was structured. The idea was that the province would pay the money directly to the transferring attorney. So our argument is it never went, if I may use the term, purse. It never went into the purse of the municipality. So when my learned friend refers to section 18.2, if one looks at section 18, one sees that the section talks about monies that are collected. 18.1a or 18.1a say an annual budget may only be funded from realistically anticipated revenues to be collected. So we submit with respect that section 18.1a does not apply. The same argument in regard to regulation 10.2, the words that are used in regulation 10.2 is realistically anticipated revenues to be received. So the revenues were never received. When I'm talking about revenue, the money, the 52 million, wasn't to be received by the municipality. So we say regulation 10.2 does not apply with respect. Then my third submission or third aspect is my learned friend, as I understood him, he referred to the letter of demand that appears in volume 1. And it starts at page 20. It's a letter dated 27 September 2013. And then my learned friend referred to paragraph 2.2. As I understood the submission, that by referring to paragraph 2.2, it means that the applicant admitted that the provisions of section 19 had been complied with. This is not what paragraph 2.2 says. Paragraph 2.2 reads as follows. The Council of Letaba approved of the transaction as required in terms of section 19.1b of the MFMA. And if one looks at section 19.1b, it deals with the approval by council. The applicant's case has always been that when council had the meeting on the 22nd of March 2013, that was a proper resolution passed by council to acquire the property. So the submission we make is we did not say that section 19 was complied with. What we say is section 19.1b, that council approved the transaction to acquire the immovable property.
Mr. De Silva, I'm sorry to interrupt you. Please look at paragraph 2.
Yes.
On the same page.
Yeah. Oh, yes. Okay. It says, well, it says Letaba properly complied with section 19 municipal fund in that. So in other words, it's a general introduction, Justice Theron, but the particulars are set up.
It's a general introduction that specifically says section 19 was complied with. Then it goes on to give the particular details that is relied upon. But the general introduction says section 19 was complied with by the municipality.
With respect, Justice Theron, you cannot ignore the words in that. It says Letaba properly complied with section 19 in that, and then the Council of Letaba approved the transaction. In other words, council met and the transaction was approved in terms of section 19.1b with respect. Then the fourth submission deals with ostensible authority. The leading case is the judgment by this honorable court in the McCarthy versus Vodacom case. And the relevant paragraphs of 45 and 46. In paragraph 45, Justice Jafta dealt with estoppel, and then he says he deals with a misrepresentation in the question of estoppel. And then paragraph 46, he says the same misrepresentation may also lead to an appearance that the agent has the power to act on behalf of the principal. This is known as an ostensible or apparent authority in our law. And this is precisely Mrs. Mashaba and the municipality created the impression that she was entitled to sign the agreement. And that creates ostensible authority, we submit. And then the last submission I wish to make, it deals with the just and equitable remedy. Section 172, 1B, Roman 2, we submit is applicable. What section 172B says may make any order that is just and equitable, including, and then Roman 2 says an order suspending the declaration of invalidity for any period or any conditions to allow the competent authority to correct the defect. So this court has the powers to make such an order. We have no further submissions. May it please you.
Thank you very much, Mr. Silva.
Sorry, Justice Matlanga. Just one small thing, Mr. Da Silva. Your whole case is that even though this was not a tripartite agreement, but there was no financial obligation on the municipality because the money was going to come from Cogstar. At some stage, the provincial treasury said it won't approve the Cogstar request for funds. When did your clients know this? Do we see it anywhere in the papers?
I'm uncertain of precisely, Justice Malambo, precisely when the applicant became aware, but one can assume the letter of demand that my learned friend referred to, that's the Bressler and Becker letter of demand, is a second letter of demand. So one sees at page 18 a letter of demand written the 23rd of April. Well, one does not know what one sees from the letter of demand is that they say the second last paragraph at page 18. It says our client has been informed by the transferring attorneys that you failed to effect payment as per the provisions of clause 4.1.1. But it doesn't appear, and I can't answer your answer with any precision or your question with any precision as precisely when the applicant became aware that Treasury had in fact withdrawn the funding for the project. Perhaps my learned junior can assist me if you'll bear with me. We can't answer your question with any precision, Justice Malambo.
So we just have to go through the record and see if we pursue that line. But let me ask you a different question, and this follows up from the questions by Justice Theron. Let's take it that your client only knew 4 years later that the municipality is not going to do anything. And they haven't explained why they sat back and did nothing until they took that point 4 years later. And let's say we say section 19 applies, we can't breathe life into an nullity. When we fashion just an equitable relief for you, what are our options? What would you argue would be our options?
Well, we sit, or the applicant sits in the situation that he sits with property that was specifically structured for human settlement. They were urban, rezoned for special type of development, and it would be very difficult for the applicant to sell the property to any other entity. And this is a submission that I make from the bar without evidence. But I submit, with respect, or we submit, that the applicant would be in a very difficult position to sell the property to any other entity other than an entity similar to the municipality, because the property was developed for human settlement. Coupled with that position that the applicant finds himself, one is also faced with a situation, as correctly pointed out by Justice Theron, that the municipality took the legality point in April 2017, 4 years later. You will recall from the papers, there was an application for summary judgment and there was an affidavit filed resisting summary judgment. And the question of legality wasn't raised in that affidavit. The first time it was raised was in April.
Well, I think that's the whole delay. Sorry to judge Ines, you are still speaking. Please forgive me for that. But what I want to test with you is, and these questions were asked when you first argued, what is the prejudice? Has there been any performance on your client's part in line with this agreement? In other words, to use the language of the courts, has the applicant altered its position arising from this agreement? And if so, has this been pleaded anyway?
Well, the question of prejudice, Justice Malambo, is not dealt with in any way. But if one reads the agreement, as I answered the question to Justice Theron, is we issued summons, or the applicant issued summons and tenders performance. We tender the transfer of the property. But if one looks at the agreement, which you will find in volume 7, the agreement starts at page 642. And if one goes to clause 5 of the agreement, one sees the different steps that the applicant has taken. For example, Greater Letaba approved the application for the establishment of the township, subject to certain, and then there's a service level agreement with Greater Letaba municipality. And if one goes on, for example, at 5.1.5, there's the installation of engineering services. So the applicant went some way in which to develop the property and make, and you'll note from the agreement, what they actually refer to, they don't refer to property, they refer to an enterprise. It's the enterprise that is being sold. And one can see what has taken place to develop the enterprise. So to answer your question, there's no evidence before the court or quo or before this court that since the agreement was signed on the 6th or the 23rd of March 2013, there's been no change in position, except that the applicant has tendered the transfer of the property.
Thank you very much. Thank you, Justice Matlanga.
Justice Matlanga, if I may, please. Mr. De Silva, arising from the questions of Justice Mlambo, you said that there had been rezoning for human settlement. When did the rezoning take place? And I ask this in light of the letter of demand that was sent by the applicants on 23 April 2013 already. There at page 19, the applicants say, if the breach is not remedied within 7 days, the applicant will institute legal proceedings to claim A, specific performance cancellation, B or C, damages. Now, if the rezoning took place after this letter was sent, how can the applicant justify, or isn't this the prejudice then self-inflicted, where the applicant realizes that there is a challenge with the enforcement of this contract and nevertheless proceeds to perform its obligations in terms of the contract?
Justice Theron, if one goes to the agreement, if you go to volume 7, And the agreement starts at 642. But if you turn to 648, and you look at the last paragraph at page 648,
Yeah.
that's paragraph 5.1.6. It says, the seller, this is before the agreement obviously has been concluded. It says, the seller, as owner of the property, has paid Jacques de Toy town planners, that's the town planners, for the proclamation of 270 stands in extension 6. And payment also has been made to the town planners for the layout of phase 3 of 197 stands in extension 3 and 710 stands in extension 4. So my submission to you is that if one looks at paragraph 5.1.6, that the rezoning all took place prior to the signing of the agreement.
One has to ask then why the applicant would take on that responsibility or liability without having a contract in place, a valid contract in place with the municipality, and whether if the applicant did that, as it appears from the papers, the municipality should then be held liable for it, where the applicant performed prior to the contract having been entered into.
Justice Theron, one obviously must take into account that a development of a property like this takes time. And if one looks at the history of the matter, what happened is the applicant purchased the property and then he develops the property and he makes the property, he makes the property, puts it in such a position that it's acceptable for the first respondent to purchase the property.
Isn't that referred to as an assumption of risk? Assumption of risk on the part of the applicant in order to make the applicant the most viable contender to enter into the contract with the municipality. And it's a risk that the applicant assumed before the contract was entered into, so as to place the applicant in a good position and to have leverage in terms of a possible contract with the municipality.
Justice Theron, I've always understood the assumption of risk to be a delictual term, but I submit that the parties negotiated with each other on equal terms. And obviously, the municipality, the first respondent, has for some time, it's common cause, that there's this dire need for RDP housing in the community. So what the applicant did is he performed in a manner that would be the most acceptable for the first respondent. But they were in an equal bargaining power, and you'll remember that there was one of the valuations that valued the property. It was valued at 80 million. And in fact, when they started negotiating, and this appears from the papers, that the applicant offered the property for 55 million. And then there was negotiation, and Mr. Mangena, who was director of the applicant, they wanted a discount, and eventually they settled on the figure of 52 million. So it was a normal negotiation that took place. The first respondent knew what it was getting, and the applicant was performing in terms of what the first respondent required, my lady.
And the engineering services, that was, if I understand how these things work, was to service the sites. Isn't that so?
Yes, they provide services for the stands, yes.
Because the stands are only erected once the sites have been serviced in terms of water and sewage. Is that correct?
Yes.
And that was a liability that the applicants undertook on its own, even before the agreement was entered into. What the agreement provided is that if the first respondent is agreeable they would cover those costs. So the applicant assumed that risk, and that's what the assumption of risk I'm talking about. The applicant assumed the risk of making this, of servicing the sites. I think that's the term they use. The applicant assumed the risk of servicing the sites in the hope that the respondent would reimburse them. And that is captured in 5.1.5 at page 648. You look at line 5, it says, should the purchaser at its absolute discretion elect to use the approved designs, it will be liable for the engineer's fees. And there's a similar provision in 5.1.6. At line 6, it says, should the purchaser, again, at its absolute discretion, elect to use the non-proclaimed layout in extension 3 and 4, it will be liable for the fees incurred in respect of that. So it's something of a misnomer to say to this court, well, the land was rezoned for human settlements. That was a risk that was undertaken by the applicant prior to the conclusion of the contract, in the hope that once the contract is concluded, the municipality will reimburse it for those expenses.
I would, Justice Theron, I would imagine that this goes to a just and equitable remedy that you're considering in putting these questions to me. One must weigh that up against the fact that the municipality took 4 years to raise the illegality defense. So the applicant went beyond the call of duty to make the property available and to meet the requirements of the first respondent. They are entering into a sale agreement. There are valuations.
That is how property developers operate, Mr. Silva, Mr. Silva. But that's making the property available for RDP housing, servicing the property. That was the risk. We specifically were asking about what steps the applicant had taken after the conclusion of the agreement to get its affairs in order to perform. So we cannot refer then to what the applicant did in anticipation of the agreement. The servicing of the sites was in anticipation of the agreement. What did the applicant do towards performing the agreement afterwards?
Well, the applicant tenders the transfer of the property. If one looks at the particulars of claim, it tenders transfer. There's an agreement concluded, and they tender transfer.
I understand, Mr. De Silva. Thank you very much. Thank you, Justice Matlanga.
May it please you, Justice.
Mr. De Silva, I'm sorry to detain you, but could I just ask you one question flowing from what my sister Justice Theron has been putting to you? In the light of the fact that the subject matter of the sale is actually an enterprise, and part of what constitutes an enterprise are the investiture of services in the land that is being sold, doesn't that square with the language of capital project? Because you've pointed to the provisions of clause 5.1.5, where what is envisaged is that if certain services are used, then the municipality will become liable for the investments already made by the seller, your client. So isn't that further contractual evidence that this is a capital project and not merely a capital asset?
Justice Unterhalter, I submit that the defender, the first respondent, in relying on the provisions of Section 19, it was incumbent upon it to show whether it was a capital project or not. At this stage, with respect, one knows there's an enterprise, and one doesn't know how far this project has to be concluded. I made the earlier submission that one would have expected in a situation like this, that possibly the housing would have had to be built and the housing would have been sold. This is
But
just.
I'm not certain that I understand why it's an onus of proof question. We look at the agreement, you've taken us to the relevant provisions, and we see what the subject matter of the sale was. And the sale was a piece of land already invested with certain services, the zoning, the services for the provision of sites and the like. That looks very much like a capital project, which would be committing the municipality, if they used some of the services already invested by your client, to further expenditure.
I submit with respect, Justice Unterhalter, that's an inference that one possibly could draw, but might not be the correct inference. And the only person that could give light into what happened here is Mrs. Mashaba. She was the one that was the municipal manager, and she was the one that would have known why they entered into this agreement. I submit it would be incorrect with respect to infer the fact that an enterprise was sold, to infer from that it was a capital project. A capital project, if one looks at section 19, is a project that can go over many financial years. And one doesn't know with respect to draw the inference. I would submit with respect, if one has to draw the inference whether enterprise is a capital project, there's a 50-50 chance that one is correct, and there's a 50 chance that you're incorrect. So it's an inference, and there's no evidence, and I submit that it must be determined on the evidence. Mrs. Mashaba was the person that knew about this, and the first respondent was the party that relied on section 19.
Yes, thank you.
Thank you very much, Mr. Silva. Thank you to
Madlanga, my learned junior has a point. If you just bear with me, please, if I might be given a second, please. My learned junior has pointed out, if one has a look at volume 6 at page 537, where Mrs. Mashaba was testifying, she said there was a question put to her, and then she said, the question was, has that been done? And then she says, I indicated that we approved the letter of commitment, which was reflecting the overall amount that was going to be spent. And the inference that my learned junior wishes to draw is that that was the overall amount. There was just one amount that was going to be spent. And it accords with the provisions of section 19(1)(b), which says the project, including the total cost, has been approved by council. So it was the total cost. I don't know if I'm not certain if that assists this honourable court any further. I don't have any further.
We've heard you. Thank you. Thank you to both counsel. Judgment is reserved. Court adjourned.
May it please you.
May it please the court.
Today's proceedings have concluded. The host will now terminate the meeting.